Welcome to What's New in Municipal Law 2020, Part 2, Recent Court and Appellate Tax Board Decisions. We've now reached the last category of court decisions. It includes cases that don't fall into the previous categories. There are 8 cases. Drake v. Lester. This case is about the Tort Claims Act and presentment of a claim. On January 19, 2016, Catherine Drake slipped and fell at Lester High School while picking up her grandson during school hours. She suffered multiple injuries, including a fractured knee and wrist. Exactly 2 years after her claim arose, on Friday, January 19, 2018, Miss Drake mailed her presentment letter via certified mail to the town. Lester received the letter on Monday, January 22, 2018. It denied liability, and Miss Drake commenced this negligence action. The Superior Court dismissed the claim, siding with the town because Miss Drake missed the presentment deadline of 2 years. The SJC transferred the appeal of the case from the appeals court to itself. The issue in the case was, what constitutes presentment under Chapter 258, Section 4? Is it the placing of the presentment letter in the mail, as Miss Drake argued, or is it the receipt by the proper executive officer, as the town argued? The Massachusetts Tort Claims Act makes a public employer liable for loss of property, personal injury, or death caused by the negligence or wrongful conduct of public employees acting within the scope of their employment. The claimant cannot institute a civil action against a public employer for damages unless the claimant shall have first presented the claim in writing to the executive officer of such public employer within 2 years after the date the cause of action arose. Proper presentment is required to commence a suit under the Act. Failure to do so is fatal to a claim. The Tort Claims Act does not define presentment. When a statute does not contain a definition for a particular word, a court will give the word its usual and accepted meaning, as long as the meaning is consistent with the statutory purpose. In this case, the court looked to Blacklaw's dictionary, which defines presentment as the act of presenting or laying before a court or other tribunal a formal statement about a matter to be dealt with legally. As a result, the SJC concluded that to lay or put an item such as a presentment letter before another, the receiving person or entity must have the opportunity to observe the item. Placing the presentment letter in the mail, certified or not, does not constitute proper presentment, as that act alone does not provide the proper executive officer the opportunity to observe the letter. Because Drake's presentment letter was not received by the officer in time, the SJC upheld the dismissal of Drake's claim. Magliocane v. City of Gardner. Janice Magliocane's hot water heating system failed prematurely 3 times due to corroded coils. Hundreds of other Gardner residents were having similar problems. In 1994, city consultants reported that the corrosive nature of the water caused the leaching of lead and copper from building plumbing. They recommended that the Crystal Lake Water Treatment Facility should add a non-zinc orthophosphate to the water. In 1998, the consultant recommended the Snake Pond facility treat the water with a soda and polyorthophosphate blend. The DEP approved of these anti-corrosive measures, but the plans were not implemented. From 2009 to 2010, the city received numerous complaints about failing copper water heater coils. In 2011, the city engineer consulted the EPA. The water had low alkalinity. The city shared this info with Suez, the city's private water supply contractor, but no measures were taken. In 2012, the city received reports of more than 400 coil failures from 250 residents. The city and Suez then hired Microvision Labs, which recommended adding soda ash and orthophosphate. The city and Suez took no action. In 2013, the city engineer told the city council that the water was tested, but it did not show anything. In 2015, the city hired corrosion testing labs, which determined that leaks in the coils were caused by pinholes due to soft water and low alkalinity. In September 2015, the city issued a press release acknowledging soft water and a low level of dissolved inorganic carbons contributed to coil failure. The city also asserted that the coil failure was due to the water's natural state. In March of 2016, at the City Council Public Service Committee meeting, the city engineer disclaimed the city's responsibility for the coil corrosion, saying, "We are not doing anything wrong." In June 2016, the city and Suez sought approval from DEP to add orthophosphate to the water. In August of 2017, the DEP approved the request. The city announced it was adding orthophosphate to make the situation go away. In October of 2017, Maglia Kane sent a demand letter to the city for herself individually and on behalf of a class of Gardner residents, property owners, and businesses who've had to replace or purchase heating coils, boilers, and hot water heaters since 2000 due to coil corrosion. In December of 2017, Maglia Kane filed the present suit. The city still had not implemented a coil corrosion mitigation plan. The city claimed that there had been improper presentment under the Tort Claims Act, and the lower court agreed and dismissed Maglia Kane's lawsuit. Under General Law, Chapter 258, Section 4, a claimant must present claim in writing to executive officer within 2 years. On appeal, the SJC overturned the dismissal because when there is fraudulent concealment, a defendant takes active steps to conceal the cause of action. Under General Law, Chapter 260, Section 12, the statute of limitations is tolled or suspended. But the city had also claimed that 2 Tort Claims Act exemptions applied. The first was Section 10J, which exempts claims based on a public employer's failure to prevent the harmful consequences of a condition not originally caused by the employer. The second was Section 10B, which states that public employers are not liable for a claim based upon the exercise or failure to exercise a discretionary function acting within the scope of their office. The SJC held that the Section 10J exemption does not apply where city took responsibility for sale and distribution of water to residents where city knew the water to be corrosive. And regarding the Section 10B exemption, the SJC held that whether city made a discretionary policy decision or failed to implement its policy decision is not clear. The case is too fact-intensive to permit dismissal based on discretionary function immunity. Dusty v. Town of Shirley. This is another Tort Claims Act decision. On September 19, 2012, Dusty and husband secured an offer to purchase their property for $182,500, conditioned on the property being buildable. The town building inspector, however, erroneously told the buyer that it was not buildable, so the buyer withdrew the offer and Dusty sued the town for negligent misrepresentation and interference with a business relationship. The Superior Court granted summary judgment in favor of the town. It stated that the claim for negligent misrepresentation was not shown by Dusty and the town was immune under General Law, Chapter 258, Section 10C, from claims of intentional interference with business relations. So Dusty appealed. On appeal, the appeals court agreed with Superior Court. The appeals court said the negligent misrepresentation claim requires reasonable reliance on the misinformation, and here, there was no evidence that Dusty relied on the building inspector's statement. There was also no evidence that the Dusty buyer's reliance was reasonable or that the buyer suffered harm. But the buyer is not a party to this suit, so his harm or reliance is not relevant. On the intentional interference with business relations claim, the town is immune under Section 10C of the Tort Claims Act. Clevin v. Newton. This is another Tort Claims Act case. Here, Brenna Clevin brought suit against the city of Newton when a water main breached and caused water, silt, and sewerage to back up into Clevin's home. Clevin alleged Newton negligently failed to warn of the risk of such event. The city claimed immunity under Sections 10B and 10J of the Tort Claims Act. The Superior Court disagreed with the city and denied the city's motion. Newton appealed. The appeals court said that Clevin's failure to warn claim is barred by Section 10J of the Tort Claims Act unless the city was the original cause of the condition that led to Clevin's harm. To qualify as the original cause, there must be an affirmative act by the city creating the harmful situation. Here, the original cause of Miss Clevin's harm was the flood from the water main break, but no evidence was offered that Newton caused the break. As a result, the appeals court reversed the lower court's decision and allowed the city's motion for summary judgment. Town of Plymouth v. Power. This is a firearm ID card case. Robert Power applied for an FID card with Plymouth Police Department. Although Power had an extensive criminal history, the town did not take position he was a prohibited person under General Law, Chapter 140, Section 129B, and did not attempt to deny the FID card on that ground. If an applicant is not a prohibited person, Section 129B, 1.5, requires the police department to petition to the district court and request the court determine the applicant is unsuitable to possess an FID card. There is no deadline stated in that section for the filing of such a petition. More than 100 days after Power's application was filed, the town petitioned district court to determine that Power is unsuitable to possess an FID card. The district court judge ordered the town to grant the FID card to Power because the court said that Section 129B3 requires approval by licensing authority or denial of prohibited person within 40 days, and the town's failure to timely issue its decision was a constructive approval of the FID card. The court also made a finding, in the event its decision was overturned on appeal, that the town's determination of Power's unsuitability for an FID was not arbitrary or capricious. On appeal, the appeals court determined that the town was required to file the petition for unsuitability in district court within 40 days, but it also determined that the town's failure to do so did not result in constructive approval of FID card. The court remanded the case to the district court judge to determine Power's suitability by the correct standard of review, a preponderance of the evidence. The standard of review is not whether town's determination of unsuitability was arbitrary or capricious. Williams v. Boston Public Health Commission. This case involves another claim under the Massachusetts Tort Claims Act. This defendant in this case, the Boston Public Health Commission, is a large independent public agency that runs over 40 different programs relative to the delivery of healthcare services in the city of Boston, including the Boston Medical Center. The commission also runs the Boston Emergency Medical Services, the city's public ambulance service. In this case, the EMS was dispatched to the Pine Street Inn, where staff members had called 911 to report that a client was experiencing suicidal thoughts. Staff informed the EMTs about the suicidal thoughts expressed by the client. EMS decided to transport the client to a local hospital. The protocol for transporting suicidal patients to the hospital called for restraining the patient and calling for a police escort. Despite the established protocol for transporting suicidal patients, there was no police escort and the patient was not restrained. When one of the EMTs opened the door to the ambulance at the hospital, the patient bolted out of the ambulance and fled past the EMT. The patient lay down on the street where she was struck and killed by a passing motor vehicle. The patient's estate filed suit for wrongful death against the commission resulting from the negligence of the EMTs and the failure to supervise and train the EMTs. In its complaint, the estate alleged that the EMTs removed the patient to an unsecure place where they could not prevent her from killing herself. The Superior Court dismissed the complaint, agreeing with the Commission that Chapter 258 provides immunity to public employers where the injurious acts are caused by a third party, here, the driver of the motor vehicle that struck the patient. On appeal, the appeals court agreed with lower court's dismissal of the claim based on failure to train supervise employees because the failure to train supervise was not the condition that originally caused the injury. But the court reversed the dismissal of the claim for wrongful death due to employees' negligence because the public employee's intervention placed the decedent in a worse position than before their intervention. The next case is a United States District Court case, Markham v. Chelmsford. This due process claim was brought by claimant Markham and the Sewer Fairness Alliance as co-plaintiffs. The alliance membership consisted of 300 households, most of which were required by the town to have sewage grinder pumps to connect to the sewer system. The town provided the pumps. Markham's pump failed during a power outage. The town repaired the pump and sent the $1,065 repair bill to Markham. Markham complained, and the town held a hearing to discuss the charge. The bill was reduced to $640. Markham and the Sewer Fairness Alliance filed suit in Superior Court alleging a due process violation. The town removed the case to Federal District Court and filed a motion to dismiss on two grounds. The first challenged the standing of Alliance to bring suit, and the second that the due process complaint failed to state a claim upon which relief can be granted, a claim that Markham's case was legally insufficient. The court denied the town's motion to dismiss. It said that Alliance had standing and that the due process claim was sufficient enough to survive a motion to dismiss. The notice and hearing required by due process under the Constitution varies with particulars of each case. In this case, sufficient due process would be best decided on a fuller record and not on a dismissal motion. The court also stated that it was not clear from the record whether, as the town claimed, the abatement remedies for taxes under General Law Chapter 59, Section 59, provided sufficient due process to Markham in this case. We'll never know the legal outcome of this case because the parties settled in February 2020. However, the fact that the town ended up as a defendant in a federal district court case over this matter provides notice that towns need to be aware of their due process obligations when sending large bills to homeowners. Rosenfeld and Comcan v. Town of Mansfield. In this land court case, Comcan is the holder of a provisional medical marijuana license issued by the State Cannabis Control Commission. Comcan also obtained a special permit from the town, allowing a medical marijuana dispensary at the location. An abutter appealed that special permit to the Superior Court and the appeal was pending. Comcan and the town had also entered into a host community agreement for the Registered Medical Marijuana Dispensary, RMD. ComCan submitted a request to the town to convert to recreational marijuana sales under General Law, Chapter 94G, Section 3A1, notwithstanding that recreational sales not permitted within the zoning district. Section 3A1 prohibited use of zoning to stop conversion of an RMD to recreational sales if the RMD was 1. Provisionally licensed or registered by July 1, 2017, and 2. Engaged in the cultivation, manufacture, or sale of marijuana. The town disagreed and said that Section 3A1 did not apply. The special permit had been appealed and ComCan had not constructed its facility. This meant ComCan is not engaged in the cultivation, manufacture, or sale of marijuana required under Section 3A1. Land Court disagreed with the town and held that Section 3A1 did apply. ComCan's actions to exercise its license constitute engaging in the sale of medical cannabis. The town cannot use zoning to prohibit conversion of ComCan's registered medical marijuana dispensary to one for recreational sale of marijuana. And that concludes our 2020 presentation of What's New in Municipal Law, Court, and Appellate Tax Board Decisions. Thank you for joining us.